Good evening, everyone. So, today we are going to understand a very important legal topic: how to draft a legally enforceable non disclosure agreement, which is usually known as NDA in India. In today's digital economy, data is one of the most valuable assets. Now, whether you are a startup founder, freelancer, lawyer, or a corporate professional, you will deal with a lot of confidential information. And this is where the NDA becomes very crucial. An NDA is legally binding contract that prevents parties from disclosing sensitive information without the permission. But here the important part is that just drafting an NDA is not enough. It should also be legally enforceable under Indian law. So first let's understand the legal foundation. Now in India, NDAs are primarily governed by your Indian Contract Act. And according to this law, a contract is an agreement which is enforceable by law. For any contract, including an NDA, to be valid, it must have offer and acceptance, lawful consideration, free consent, competent parties, and lawful object. If these elements are missing, your NDA will not stand in court. Now, one very important provision is Section 27 of the Indian Contract Act. This section says that restraining a person from carrying a lawful profession is void. So, what does it mean? You cannot stop someone from working elsewhere, but you can stop someone from disclosing confidential information. This distinction is critical while drafting an NDA. Now, there are three different types or three main types of NDA. There is a unilateral NDA wherein only one party shares the information. There is a bilateral NDA where both the parties share information. There is a multilateral NDA, that is where more than two parties are involved. Choosing the correct type depending on the situation. You need to choose the correct depending on what is your requirement. Let's move on to the next important step. That is, how exactly are you going to draft an NDA step by step? So, first clause, your standard clause, that is your details of the parties, etc. Now here, instead of scope of work, you will begin with the definition of confidential information. You need to mention what exactly is confidential. Don't make the mistake of writing everything is confidential. It doesn't work that way. Instead, you need to specify what it is, whether it's a business strategy, client list, financial data, source code, trade secrets, because codes tend to reject vague definitions. Parties to the agreement. Clearly identify who is the disclosing party. That is, who is going to disclose the information. Who is the receiving party? Who is going to receive the information? You need to include their full names, legal names, and their addresses. Purpose clause. Mention why this information is being shared. That is, this information is being shared for the evaluation of a business partnership. Without purpose clause, your enforcement becomes very weak. Then comes the obligation of receiving party. Now, I'm getting information from someone else, but what am I supposed to do with that information? There have to be some deliverables on my part. So this clause will clearly state that you do not disclose this information, use the information only for a very specific purpose, maintain reasonable security. Okay, these are the three main important obligations. You can add more obligations again depending on your uh, scope of work or your scope of uh, information that is being shared. Then comes your exclusions clause. That is, your NDA has to include what is exclusive, what is excluded. That is information that is not protected under this agreement. Publicly available information, because you can't, it's already available in public domain. You can't enforce it under an NDA. Information which is known prior to entering into this agreement, independently developed information. Without this, your NDA may be considered unreasonable. Then comes your duration clause. To what extent this NDA is valid? You need to mention the specific duration. even the survival period after termination. That is, even if we terminate this agreement, till what extent, till how much amount of years you are supposed to keep the information confidential. For example, this obligation shall survive for 3 years after termination. Remedies for breach. Now, under Indian law, you can claim damages under Section 73 and Section 74. You can also seek injunctions from the court. You also need to include the disclosing party shall be entitled to receive injunctive relief and damages. Then comes your non-compete clause, which is a very sensitive and a very important clause because you have to be very careful while drafting it. So, how you would draft it is that post-employment non-compete clauses are usually void under Section 27. Okay, but court will allow you to have a confidentiality clause which will still be effective because it is not a restriction of profession. For example, if a person is an employee of company A, which is, let's say, a cab aggregator, he decides to go and join company B, okay, which is also a cab aggregator and is the competitor of company A. Now, while working in company A, the employee comes across certain confidential information during his course of work. It may not be given to him saying that this is confidential information, but yeah, there are certain informations which cannot be defined. He cannot share those with the competitors. He can join his competitor, but he can be restrained from sharing the information. That is the whole purpose of having an NDA. Your jurisdiction clause. Always specify. Now, the governing law will always be your Indian law. If it's an Indian agreement, jurisdiction, you also need to specify which city you're going. For example, it's Mumbai, Delhi, Bangalore, wherever the head office of the company is situated is usually where the jurisdiction is. That has been the standard practice. Your stamp duty requirement. Now, in India, you need to have it properly stamped. Otherwise, it may not be admissible in court. Or you can also have it on the letterhead of the company. There are two options for the same. Then comes your severability clause. Now, if one clause becomes invalid, the rest of the agreement should become valid. This is generally known as the blue pencil doctrine. Let's quickly look at some judgments which are related to NDA. So one, we have the common Niranjan Shankar Golikari case, in which the court had held that confidentiality clauses are something that is valid, but restraint of trade is something that's not enforceable. So even if a person quits his job, confidentiality clause is something that he will have to enforce. Then is Percept Demark versus Zahir Khan. Here, the Supreme Court had ruled that post-contract restrictions are void, but protection of confidential data is valid. Now, let's talk about the common mistakes that a lot of people make while drafting. One is definitely use of vague language. Vague languages do not help anybody. Okay, so even when you're copying a template, it's always a vague language. You need to be very specific on what is the information you wish to share, what is the information you don't wish to share, what is your confidentiality. What may be confidentiality for your client may not be confidentiality for the next client. Then comes including illegal non-compete clauses. Remember the difference between non-disclosure, confidentiality, and non-compete. Most of the lawyers may forget the distinction between the both, and that is where an NDA becomes invalid. Not specifying the duration. Now, till what extent am I supposed to protect this information? Whether it's 3 years after I'm being employed, whether it's 5 years, you have to specify the duration. I have seen NDAs wherein they put a clause of perpetuity, but perpetuity is not valid because in today's technology friendly world or technology developing world, your confidential information changes within every 6 months. So standard duration we usually use is 3 to 5 years. Then comes copy pasting generic templates. Please don't do it. It's a huge disaster. You can use it as a reference. Okay. So remember that a poorly drafted NDA is worse than having no NDA at all. Then, before finalizing your NDA, there are a few things that you need to ensure. That is, you need to clearly define the definition of confidential information. You need to have valid contract elements. You cannot use restraint of trade. It's a clear violation of the Indian law. You need to have a remedies clause, that is, you need to mention that the person who's disclosing information is entitled to interim relief and whatever other damages. You will mention the jurisdiction. So, to conclude, an NDA is not just a legal document, it is a shield for your business. But the strength, it depends entirely on how well it is drafted. So, if you remember just one thing from today's session, that is, you cannot restrain somebody's career, but you can protect your confidential information. Thank you so much for being a part of this session, and I'll see you again within the next 2 minutes. Thank you so much and have a great day.